Good morning, everybody. Welcome this morning to Sedgemoor District Council's Licensing and Gambling Panel on Monday, the 4th of April. I'm Councillor Polly Costello. I'm the Chairman of the Licensing and General Purposes Committee for Sedgemoor. I'm also a Ward Councillor for Wedmore and Mark. I'll just do some quick introductions around the room before we crack on. So I'll start from my left.
Yeah, good morning, everybody. Yes, I'm Councillor Stuart Kingham, as you can see, and I'm the ward member for the West Podens.
Good morning, everyone. My name's Alec Glasswood. I'm ward member for Fairfax.
Oh yes, we'll start down the end for our list of speakers today. Okay.
Laura Maynard, resident. Jean Matthews, resident.
Anthony Joyce, resident.
Thank you.
Councillor Janet Keane, a ward member for Highbridge and Burnham Marine.
Councillor Alan Matthews, Sedgemoor District Councillor for Highbridge and Burnham Marine, Town Councillor for Burnham Marine, and I'm also representing Burnham and Highbridge Town Council.
Elizabeth Wiles, resident of Brew Crescent.
Louise Peace, resident.
Robert Collard, resident.
I'm Michael Beck, I'm the General Manager of the Haven Holiday Village.
I'm Jonathan Smith, I'm a solicitor from Poppleston Allen, representing the applicant.
Hi, I'm Chris Tarrant, I'm Regional Entertainment Manager for Haven.
Matthew Hayes, Acoustic Consultant from RSK Acoustics.
John. Good morning, Richard Noakes, Licensing Officer.
Good morning, Alan Weldon, Licensing and Fraud Manager, Sedgemoor District Council.
Osborne, Legal Advisor to the panel.
Steve Taylor, Committee Manager.
Super, thank you very much. Just before we begin, I just want to read this out today that this panel sits today as the licensing authority for the District of Sedgemoor, not the planning authority. I've just got to make that clear. We're here for licensing. They are two distinct regimes governed by their own rules and regulations. Therefore, any representations regarding the current planning permission, absence of any planning permission or any future planning application will not be considered as part of these proceedings. Thank you. We'll start with the agenda. Item number 1 on today's agenda is apologies for absence.
No apologies.
We don't have. Item number 2, urgent business.
No urgent business.
None of that. Declarations of interest, which we do not have. Thank you. Item number 4, Burnham-on-Sea Holiday Village. We're here today to consider an application for a variation to an existing premises licence for the Burnham-on-Sea Holiday Village, Marine Drive, Burnham-on-Sea, TA8 1LA, following objections having been received. The report has been attached. And I'd like to hand over to our licensing officers today. Mr. Weldon.
Thank you, Chair.
You.
Thank you, Chair. Good morning, everyone. Good morning, members. The matter before the panel today is to consider an application for a full variation to an existing premises licence in accordance with the Licensing Act 2003. On the 8th of February 2022, an application for a full variation to an existing premises licence in respect of the main complex of Burnham-on-Sea Holiday Village, Marine Drive, Burnham-on-Sea, was served on Sedgemoor District Council, the licensing authority, by Poppleston Allen solicitors on behalf of the applicant, Haven Leisure Limited. At the time that this report was constructed, the application was seeking authorisation for the following: the incorporation of a container bar within the external outside area, which is currently already licensed for the retail sale of alcohol, the incorporation of an external stage area to be licensed to provide the following activities from 1100 to 2300 hours, Monday to Sunday: the performance of plays, exhibition of film, boxing and wrestling entertainment, performance of live music, playing of recorded music, performance of dance and entertainment of a similar description to the aforementioned activities. The adding of a plan to the external area of the premises to the licence in order to clarify the changes requested, and the amendment of existing conditions attached to the premises licence to update these in light of the changes that were being requested as a result of the application. The applicant confirms that there are no changes to the layout of the other existing licensed areas of venues at the property. There are also no changes being requested to the existing licensable activities or permitted hours for the existing licensed areas at the venue. As you will see, a redacted copy of the application and the associated plan are shown as Appendix 1 and 2 respectively. Appendix 3 provides a summary of the change to conditions already mentioned and copies of the plans on the existing licence that are referred to in the application by drawing numbers. The current position has changed since this report was published following discussions between the applicant and regulatory consultees. You would see as part of your initial report, Appendix 4 is a summary of an agreed position that the applicant took with the police for the panel's consideration today. Appendices 5 and 6 relate to objections that were submitted on behalf of environmental health in terms of a health and safety concern and also a pollution control concern. The position with those 3 appendices has changed. Just to clarify, the police did not object and reached agreement before the end of the consultation period. Well, as you will see from appendices 5 and 6, objections were registered on behalf of environmental health. Now, I do appreciate a lot of paperwork has been submitted quite late in the day in regards to this application, as discussions were permitted to be ongoing more or less until at least 24 hours before the hearing. So if I can refer those of you that have them to your additional packs, please, which start with Appendix 91 on the front and page 144. But if I'd like to refer you, please, to the very back of this document, starting on page 221, these are a set of conditions that are proposed today for the panel to consider to be added to any licence that may be granted today. And this represents the agreed positions I've spoken about. And this is a combination of those positions: police, environmental health, health and safety, and environmental health, pollution. Now, as these have gone through quite late in the day, as is permitted within the time frame, however, I will take the opportunity to read the conditions so that people are familiar with what the agreed position is now. So, as I say, for those of you with the documents, starting on page 221, General Condition 1, an appointed person shall monitor during a period of regular entertainment in the outdoor area shown on drawing 3176.4.01 and edged in red. For the removal of doubt, that drawing is in fact the plan that was submitted with the application, which I've already referred to. The monitoring shall be carried out at frequent intervals throughout the period of regulated entertainment, and if a complaint of noise were to be received during the operating hours of the stage, appropriate action shall be taken promptly to reduce noise nuisance to nearby local residents. Condition 2, any regulated entertainment provided in the outdoor area shown on drawing and edged in red will only be provided between the Friday, which is 3 weeks before Good Friday in each calendar year, and the end of October in each calendar year. You will see there's a heading then for noise limiting device. Condition 3, a sound limiting device located in a lockable cabinet shall be fitted to any musical amplification system in the outdoor area shown on the drawing and edged in red, and set at a level to be agreed with an authorised officer of the environmental health team of Sedgemoor District Council to ensure that no noise nuisance is caused to residents. The operational panel of the sound limiting device shall then be secured to the satisfaction of the authorised officer. The key securing the sound limiting device shall be held by the licence holder or authorised manager only and shall not be accessed by any other person. The sound limiting device shall not be altered without prior agreement with the environmental health team of Sedgemoor District Council. The sound limiting device level may be reviewed and adjusted by the environmental health team of Sedgemoor District Council should substantiated complaints of nuisance be received from residents. Condition 4, any regulated entertainment or activity using the speaker or public address systems in the outdoor area shown on the drawing and edged red shall be played through the approved set sound limiting equipment. Moving on to entertainment activities, condition 5, any regulated entertainment provided in the outdoor area shown on the drawing and edged red will only be provided for those people who are holiday makers staying on the park. Condition 6, there will be no regulated entertainment provided in the outdoor area shown on the drawing and edged in red in the form of karaoke or boxing or wrestling. Just a point there, I think, to pause. That, I think, means, and I'm sure the applicant will confirm, that the licensable activity of boxing or wrestling has been removed from the application. Condition 7, the licence holder or nominated person shall maintain a noise incident log of key actions, resident complaints to the premises, noisy events and any noise interventions. This is to be made available to authorised officers on request. Operational hours, the hours of the use of the outdoor area shown on the drawing and edged in red shall be between the hours of 11 a.m. to 9:30 p.m. for plays, live and recorded music, performance of dance and entertainment of a kind, and 1100 to 2300 hours, 11 p.m. for films Monday to Sunday. Just to pause again for a point of clarification, the original application requested activities till 2300 and some of those activities have now changed their terminal hour to 21:30 p.m. Again, I'm sure the applicant will confirm that. Condition 9, any regulated entertainment provided in the outdoor area shown on the drawing and edged red will only be provided between the Friday, which is 3 weeks before Good Friday in each calendar year, and the end of October in each calendar year. Condition 10, the licence holder or nominated person shall ensure that no regulated entertainment, including live or recorded music, shall occur at any time in any external areas of the premises, apart from the stage and screen shown on the drawing and edged in red. Condition 11, the licence holder or nominated person shall ensure that reasonable measures shall be taken to advise customers to keep noise down as they leave late at night, to include suitable and sufficient conspicuous signage asking patrons to show consideration for neighbours by keeping noise to a minimum as they leave. Condition 10, the licence holder, Condition 12, the licence holder or nominated person shall ensure that no fireworks or other pyrotechnics shall be used other than with the prior written consent of the licensing authority and with 14 days notification by email to the licensing email address accompanied by a firework method statement and site plan. Points relating to resident complaints. Condition 13, a contact telephone number and email address will be provided to all residents living on Brew Crescent, Maple Drive, Atlantic Crescent, South Esplanade, Bayview Gardens, Margaret Crescent, Channel Court, Holme Close, Severn Grove, Lundy Drive and Highburn Close, which number will be contactable by residents during any regulated entertainment provided within the outdoor area shown on the drawing and edged in red. A record of any complaints will be retained on the holiday park together with the summary of what action has been taken in respect of the complaint, and such records will be made available to the licensing authority on request. These records will be retained for at least 12 months. 14, monthly meetings will be arranged by the premises licence holder between the months of March and October, with those residents invited who objected to the application to vary the premises licence to permit outdoor entertainment to 2300. 4 final conditions, which are actually separately numbered 1 to 4. Number 1, there will be no charge made by way of a ticket or otherwise for people to watch the entertainment in the outdoor area shown on the drawing and edged in red. Condition 2, I won't read out in its entirety. It's a CCTV condition that is required by the police. In respect to this application, the premises must install and maintain a comprehensive surveillance system covering all in and outdoor public areas where licensing activities can take place. The rest of the condition relates to the technical requirements of that. Condition 3, the requirement for security in the outdoor stage area will be risk assessed by the premises licence holder, and security, if required, will be provided in accordance with the recommendation of such risk assessment. Finally, the outside entertainment area is to be operated and maintained in accordance with the company's policies, procedures and risk assessments, including the open water policy. 2 points of clarification, I think, now. Firstly, these are the final set of agreed conditions to be considered by the panel today. I am aware that on page 154 and 155 of the same document, there are a set of proposed conditions. These are the final version of those, I think, is what we're looking at, and they're therefore superseded. These are the final version. Finally, in view of this agreed position, the objections shown in appendices 5 and 6 of the environmental health officers in the main report are now withdrawn. So those objections are withdrawn, beg your pardon, in respect of this agreed position. Right, that's a lot of paperwork, as I can appreciate. If I can refer you back now, please, to, I will refer to this additional document in a second, but if I can refer you back to the original report and back to paragraph 3.4. Having dealt with the regulatory consultees, you will see that appendices 7 and 8 of the original report refer to representations made by ward councillors Janet Keane and Alan Matthews, respectively. These objections still stand, as does the objection submitted by the Burnham-on-Sea and Highbridge Town Council, which is shown in Appendix 9. A number of objections were also received from nearby residents. On page 33, and again I'm referring to the original document with the pink cover, will show Appendix 10, which provides a plan of the surrounding area, highlighting the roads where some of the objections have come from residents that live there in proximity to the licensed premises. Objections have also been received from residents in Atlantic Crescent, Quantock Court on South Esplanade, Severn Grove and Burnham Road. These still stand, and as shown, as you will see, there's a list of names and appendix numbers from paragraph 3.7. Effectively, that relates to appendix 11 to 90 inclusive, as I'm sure you've seen from the report. Apologies again, referring you to the other document, you will see that for the first few pages, appendices 91 to 94, there are additional objections that weren't included in the original paperwork, but were received in time and accepted from Catherine Brown, Mrs. Gwyneth Bowengate, Constance Davis and Elizabeth Wiles. You will also see, following on from that, starting from page 150, there are additional points raised on behalf of some of the objectors whose objections are shown in the appendices. You will see that this is raised by Melissa Toney of GL Law on behalf of those objectors whose names are listed. And you will see from that document that some of the points raised in the initial proposed conditions on page 154 and 155 are referred to in that document. In terms of completing the information in the second pack that you have before you today, you will see on page 153 to page 220, there is a pack produced by the applicant which contains documents which are referred to on the contents pages of 153. As you will see, that runs out just before those conditions that we've already referred to and gone through for clarity. In terms of the matters before the panel today, the options are, I should say that other representations to those already described were received but not considered as relevant due to a lack of detail and no link to the licensing objectives, which is a requirement for submitting an objection. The options before the panel today are to grant the application as applied for, to grant the application with attached conditions, or to grant the application in part, or to grant the application in part with attached conditions, or to refuse the application. As you will see from the original report from paragraph 5, the legal comments are there. The licensing objectives concerned being the prevention of crime and disorder, public safety, the prevention of public nuisance, the protection of children from harm. The issue for the panel is whether the application as submitted sufficiently promotes the licensing objectives, whether the promotion of the licensing objectives requires the application to be granted subject to conditions, or whether the application requires it to be rejected because the licensing objectives cannot be met by the imposition of conditions. That's the conclusion of my report, Chair. Thank you. Unless, of course, there are any questions.
Lovely. Thank you very much, Mr. Weldon. Any questions for Mr. Weldon? I'll start with my panel members. No? Any objectors? Got any questions for Mr. Weldon? Yes. Thank you. Would you like to, someone like to pass the microphone down, please? Ideally, if you could just use it, it would be great. I don't know whether you do or not. I wouldn't say.
These conditions, to be clear, are agreed between you, the council, and Haven. Nobody bothered to come and speak to us. So we're not a third party to these. They are not agreed in any way. No. We've not even had time to consider them. They've been here today.
Mr. Weldon.
Just a point of clarity that they're not agreed between the licensing authority, which is the panel today. They're agreed with regulatory consultees. So in this case, the police and environmental services. So the licensing authority wouldn't necessarily be party to those discussions. The essence of the consultation period, and it is arguably short at 28 days, but that's a prescribed period. And also then the period between the end of the consultation and the hearing doesn't offer much time. But part of it is that there are statutory consultees that are consulted, and their expertise on certain matters is called into the equation, and the applicant and those consultees come to an agreed position based on the consultees' concerns. So I take your point. I appreciate it's not agreed with the objectors, but the role is for regulatory bodies to liaise with the applicant to allay any concerns that the regulatory bodies have, and that's what's happened as part of the normal process.
All right, thank you. Anybody else? Lovely. Could you have the mic, please? Thank you.
I noticed that the applicant has now submitted a noise report. This is the first time I've ever had a look at the noise report, and I'm sure there are certain council officials that have never seen this noise report before either. As somebody who's dealt with noise issues at public inquiries, I can tell you that noise expert reports are challengeable by other noise experts, and that is a process that takes time. And therefore, all I will say is that you can not accept that noise report as it is without it being reviewed.
Thank you.
Yeah, I can only say that my colleagues in environmental health did consider the report and liaise with the applicant on that basis. Unfortunately, not being a noise expert, I don't think I could comment any further on that, other than to say that environmental health was fully engaged, as I understand it, with the applicant, and the applicant may be able to confirm that as part of their representation at some point.
Have we got any questions for the licensing officer? Anybody else from the objectors? No? Applicants, any questions for Mr. Weldon? Lovely.
Can you hear me? No, thank you.
Thank you. Mr. Osborne, have you got anything? No. Super. Okay. At this stage of the panel, we'll now listen to the applicants. So I take it, Jonathan, are you doing the speaking? Lovely. If you'd like to present
yes,
your
thank you.
application to us. Thank you.
Yes, I'm going to do the speaking today, councillors, residents. Can everybody hear me, objectors? Yes? Everybody at the back hear me? Yeah? Okay. So I'll be doing the speaking. I do have a number of people with me, General Manager, the gentleman who's responsible for licensing from Haven, Chris, who's responsible for entertainment, and I do have the gentleman from RSK, the acoustic experts, here as well. So I'll do the talking. They're there really because no doubt there will be questions from yourselves and also from local residents. Could I just ask one point of clarity, Madam? Is it Madam Chair? Shall I call you that? Or
Yes, lovely.
Councillor Costello. What is the order on the summing up? Because I see that is down to your discretion as to who sums up first, second, and third.
Well,
I heard that.
there you are.
Okay.
Usually the applicant is last.
Thank you very much.
Okay.
So it is an application to vary a premises licence, and I do thank Mr. Weldon for possibly one of the longest licensing officers' reports, but it's helpful to set it in some context and for clarification for yourselves. There are a number of limbs to the variation, and the details are on page 7 of your report and also on page 14 of your report, which sets out in the application what we're seeking to vary. So the first aspect is we would ask your permission to place a container bar in the outside area. It's shown on the plan and I'll come to it. It's because the container bar is something which is temporarily in a fixed position, and I'm sure your licensing officers will tell you if you put something temporarily in a fixed position on a plan, you should seek approval from the licensing authority for that. It is going into an area, to be absolutely clear, because I know there's been some concerns and doubts expressed by those who've objected that this area is already licensed for the sale of alcohol. So the area we're talking about was licensed for the sale of alcohol back in June last year. But we do need permission to put something which is a more permanent nature into that area. What we had last year was one of the trailer bars, so you pull it in on the back of a vehicle, it's on wheels. That does not require permission because it's not temporarily in a fixed position. So that area has already traded last summer with a bar there. The application, obviously, which has drawn most attention, is that for outdoor entertainment, which I'll come back to in greater detail. Originally 11 a.m. to 11 p.m, and as you've heard from Mr. Weldon, that's been modified. But there are also then consequential amendments as a result of the application, which is slightly tricky, but there's a condition on the licence that requires outside live and recorded music to finish at 10 p.m. We're obviously seeking to change that. Obviously, actually, part of it to 9:30, so cut it back actually for 30 minutes, and also to go to 11 o'clock for other entertainment. But also there's various plan numbers referred to in the licence, and if you were minded to grant the application with the stage and the container bar, then there will be a new plan that's referred to in the conditions. These are consequential amendments, I'm sure Mr. Osborne will advise you, so it's effectively replacing the plan numbers that are there with the new plan number if you're minded to grant the application. So that's the application before you. I'm going to just touch on those that are more tricky, to say the least, with the 11 o'clock to 11 o'clock for the entertainment, which has been modified. But if I could just go to the container bar first. In your pack, councillors, at page 215, you see it's called a box bar there. It's document 10. That gives you an idea of what a container bar is. And if you turn to page 214 and 213, these are some of the visuals. We did make these available. They were stuck on the walls during the local residents' open days that we held. So we've done a bit of a before and after as to what it currently looks like on page 213, document 9, with what we'd like it to look like on page 214. And you can see the orange block, which is the container bar. Now, in all likelihood, what will happen to that, I understand, is that the window to that container bar that you can see pointing out to the swimming pool, can you see where the orange block, can you see that,
Yeah, it's
Councillor?
not orange because it's black and white, but yes.
Oh, is it?
Yeah, we can see something that we can see something that has a black window.
It's
pointing to the pool, yeah.
There's a problem. So it's if you see the swimming pool, it is to about 11 o'clock or about 57 minutes on to the swimming pool if you're looking at it from the south, looking up to it. Then you can see the stage area, which is opposite the orange container bar, to approximately sort of 1 o'clock, 2 o'clock from the container bar, running in a diagonal line. I stress again, it is going into an area which is already licensed. We used the trailer bar last year. There was no issues with us using it. Nicola Cooper from Avon and Somerset Police has obviously been consulted as part of the application. We have offered up as additional conditions as a result of this application that it will only be polycarbonate and plastic glassware which will come out of that container. That was already in the original application, which is why it's not in the list of conditions. Well, we then have the CCTV conditions. So Avon and Somerset Constabulary asked for an enhanced CCTV condition, councillors, as a result of us having a more permanent structure for the sale of alcohol. And I'm not going to read that entire CCTV condition, but it is the standard Avon and Somerset one that's used. We may have security in the area. That's mentioned in the conditions. It'll be risk assessed if we need to. It's condition 3 on page 224 of the conditions that Alan's already read through to you. That was suggested by us. It wasn't requested by Avon and Somerset Constabulary. We'll say we will risk assess if there was something unusual we're doing in there. We wouldn't normally need it for the kids' entertainment that we put on, nor for the acts or the films. But on occasions, if there's something going on there, that we think this is a bit different from what we normally do, then we would risk assess it in terms of any security needed. So we're not changing the hours. We're not looking to extend the area in which alcohol can be sold. That is an existing area, councillors. What we're seeking is to put the container bar there. And what I should say is if you're against us on the entertainment, there's absolutely no reason, I'm sure Mr Osborne will advise you, why you can't still approve the container bar. So if you say, oh, well, you're not having the stage or the entertainment, we could still have the container bar. But there is some, in some of the representations, in particular the letter that came from the solicitor on behalf of some of those making representation, which talked about an increased risk of street drinking in the town, increased noise from drinkers, excessive all-day drinking. Well, we had an outdoor trailer bar last year in the same area. I don't understand why us having a container bar is going to make any difference to what we were doing last season. So to stress, no change in the hours and no change in the areas, councillors. So the entertainment to 2300, which is where, originally to 2300, which is where the vast majority of the representations are made. We've obviously modified the hours. We've modified them to 9:30 for all forms of regulated entertainment, retaining 11 o'clock for films. We've changed it for 12 months of the year to start 3 weeks before, before Good Friday. We did that because our season sort of starts at Easter, but you never quite know when Easter's going to start. It's quite early, the holidays this year. I think it's 2 weeks before Good Friday. Some schools may have broken up a week before even that. So that's why we've asked for 3 weeks before Good Friday and then running to the end of October. Now, this is the bit that gets a bit tricky, and I'm going to have to get a bit legalistic. I apologise, residents. I think I may have spoken to some of you about this, and I'm sure Mr Osborne will advise you further, but it's slightly a strange application in that there's something called the Live Music Act 2012. For those of you who remember Fergal Sharkey, he was the gentleman behind this. It was designed to encourage live music, live entertainment. By that act, we can hold recorded and live music already in this area between 8 o'clock and 11 p.m. We could do it for up to 500 people, and we don't need permission for that, live and recorded music. Likewise, we could have a performance of dance, and we could have plays. It's legalistic, but we've made the application for two reasons. One is, first of all, it doesn't cover films. So if we want to show films, we'd need permission. The deregulation does not include films. But also, in order to take advantage of the recorded music side of things, the bar would need to be open in the premises, and it would need to be selling alcohol for consumption on the premises. So we've made that application, but we'd be under 500. We're within the hours that the Live Music Act covers. But what the Live Music Act also does, and this is very strange, and I have mentioned previously, is it suspends any conditions from this license which relate to live or recorded music. So we've offered all these conditions, but legally they're suspended if you were minded to grant the application. So I'm sure Mr. Osborne will advise you. It's unusual, but that's what the legislation says, that they are suspended. So what's the point in me offering them? What's the point in us putting this to you today? We have been accused at residents' meetings, only by a couple of people to be fair, of riding roughshod over local residents. We could have just cracked on, actually. We could have just gone ahead and done live and recorded music 8 till 11, not through a limiter, without any complaints, logs, complaint numbers, etc. We've put forward those conditions, and I am telling you, councillors, we will observe those conditions, albeit they couldn't be enforced. But for the record, and this meeting is recorded, I assume it's recorded verbally. I assume it's recorded. Yes. For the record, we will observe those conditions, councillors. So residents, we will observe those conditions. We'll do what we say. Now, if there is a nuisance caused, then by the Licensing Act, a review can take place and we lose that permission to provide the live and recorded music, and we lose that permission, we can lose that permission to have those conditions suspended. So if you like, it's a one strike and you're out. So we can be taken to review and you can take them back off us, councillors. But it's a strange scenario where I'm not putting conditions to you, but I only felt it right that I explained that to you, and I'm sure Mr. Osborne will take it away, rub his head and look at the Live Music Act. So again, just to stress, for the benefit of the residents, those conditions that are there will apply. We will apply those conditions. They're only suspended in respect of live and recorded music, so they wouldn't be suspended in terms of films, performance of dance, entertainment of a similar description, or plays, but they are suspended for live and recorded music, but we will observe them anyway. It's too complicated if we start saying, well, we're not going to do noise monitoring for a tribute act, but we are going to do it for films. It's just too complicated, so we will stick with those conditions, councillors. And if we don't, I'll be back here explaining why we haven't.
Yep, indeed.
So the application was originally submitted. It was submitted 11 till 11. And it's fair to say, and we've acknowledged this at the two residents' meetings we've held on the 22nd and 29th of March, we were surprised at the level of representation. We acknowledge that. Had we known that was going to be the reaction, we would have done it the other way around and held the residents' meeting before we lodged the application. Something we've done elsewhere, I don't know if you're aware, Bourne Leisure have 36 caravan parks, havens? 38, sorry. They have them all over the country, they're haven. I've done applications from them in Primrose Valley where we lodged an application for a stage. It was originally approved, and we made some amendments to the how the stage was to operate, and we pre-consulted with residents who'd objected to the initial application. But we had not, as a company, received any complaints to head office. There's a freedom of information request in your bundle at page 218, which I made of Sedgemoor District Council, who confirmed that in the last 5 years there'd been one recorded complaint which related to excessive machinery and plant noise. I believe there has been no complaints made directly to Burnham-on-Sea and Highbridge Town Council about noise, music noise from the premises. So we were surprised with the level of representations. We held the meetings with local residents, and we have taken cognizance of some of what has been requested in terms of hours, a complaints procedure, a telephone number and email address. We've had a number of temporary event notices issued. So I look back 5 years and we'd had a total of 14 days covered for various owners' events between 2017 and 2019. They'd all been granted. We hadn't had a complaint. I did, however, find one in 2015 where we'd had a complaint from a resident to the council, it was back in 2015, about a temporary event notice for an owners' party, which we believe went in a marquee on the car park, which is actually to the front and towards Atlantic and Butte Crescent. So you would get complaints from that, and we've not done that again. So that was the only complaint I could find, and we've looked after the licensing for Haven in this park since the license was granted back in 2005. I know it's the Licensing Act 2003 residents, but it didn't start until 2005. So we have, during the meetings that we've had with local residents, it has been expressed to us that they have complained in the past about music, about other issues, and that it's fair to say that the meetings that we had, the open days, they went quite wide. They went a lot wider than the stage area and the entertainment. There was lots of things discussed, lots of tree cutting and etc. So we went quite wide. Michael's been at the at this park for 2 years, coming up 2 years. It's your second season. So this is his second season. Last season, Michael did receive a couple of complaints about trees, and he actioned those once in March 21 and again in January 2022. So he did action those. I know that Michael's spoken to the previous manager who was there for 4 years, Lowry, and we couldn't find any specific, well, he didn't point us to any specific complaints. But obviously it's a tit for tat with local residents say, well, we have complaints, but we sort of need to know the date and time so we can investigate what's happened. Local residents say they tried to call or they popped into reception and haven't been able to talk to the general manager. It just doesn't get through. A number of the residents do talk about historic noise issues, and I think we've managed to work out through where the complaints have come from, because if I've studied them in some detail, you'll be surprised, councillors, that there's about 80, I think there's 86 there. Of the 86, 30 mention that they have already suffered noise from music, and of those 30, 23 are towards the east, and that's towards Home Court, towards Atlantic Crescent, towards Butte Crescent. It's to the east side if you look at the plans. That's towards the driveway, and it's also near to where the caravan sales area is. Now, certainly in the caravan sales area between 2016 2018, there used to be they did used to put a singer in that area who would sing to attract people down to the sales area. That has stopped in 2018. That is what they may have experienced in the past. Certainly last year, if there'd been noise complaints, it was unusual last year. Government guidance indicated we had to provide maximum ventilation to licensed premises. So we did open doors and windows to allow as much ventilation as possible for those people who were in the mash and barrel and the show bar. So doors and windows would have been open, and there may have been some noise breakout. Now that obviously won't be happening. That's touching wood and keeping lots of fingers crossed that won't be happening again. So the meetings were very well attended by local residents. I think more than 80 came along. Some people came more than once. So it was well attended. And what became apparent is that the communication channels for local residents needed to be better. So Michael has very bravely and given his email address, his work email address, and I know that residents have already been in touch with Michael about various issues by email. So we've offered that as a condition, that an email address, but also a 24-hour security mobile telephone number is available, and that is in the conditions, councillors. It's condition 13 about residents' complaints. But we also felt, and they were useful, these residents meetings. I don't know whether I'll be asked back to the next one, I don't know, but Michael is going to have monthly meetings. You're going to do this anyway, aren't you? We're going to have monthly meetings with residents. We're going to invite the same people back who objected to the application. And Michael will do that whether this is granted or refused. And also, councillors, we will still provide a telephone number and an email address to residents, and the streets are listed there. I think they're all the streets that objected. We will also do this whether it's granted or rejected. The monthly meetings then will be a good chance to catch up if there's any issues, but also the local residents did ask, can you tell us when your entertainment's happening? What is your entertainment schedule? The entertainment schedule is set monthly. So by doing that, I think I'm right in saying that, aren't I? So it's set monthly. By doing the meetings monthly, we can then provide local residents with, this is what's coming up the following month in terms of entertainment. So to stress again, we would have pre-consulted had we known the level of feeling. It was driven by, I don't know if, I'm not on Facebook, but I'm advised it was driven by, shortly after we made the application, a posting on Facebook which described what we were doing as a mini Glastonbury. To be absolutely clear, and this is reflecting the conditions, the outside public are not invited. It's not advertised, and we don't make payment. You only know what entertainment is going on as a result of booking a holiday, and then you get an app. The app. You get on an app, you get your booking, and it shows what entertainment's happening. So to be absolutely clear, there is no mini Glastonbury. We've never done karaoke. Now, maybe the singing wasn't great in the caravan sales area, so it was actually done by members of staff. We have not done karaoke. It is not a mini Glastonbury. There will not be parking issues because the only people who will be attending will be those who are on park. The outdoor stage itself, what will it look like in the entertainment area? If I could ask you just to have a look again at the pages 213 and 214. That gives you a flavour, and I'll come back to exactly what's going on in there in a moment. And then you've got pictures, councillors and local residents, which I think the residents have seen, of pages 208 to 211. The pictures you've got there are from the stage at Caister, which is in Great Yarmouth. We received approximately 22 objections to that, which acknowledged was about a quarter of those we received here. That application was refused. The application was granted with a noise limiter requirement, and we made a call to Environmental Health at Great Yarmouth just to double check there have been no complaints about performances on that stage last summer, and no, there were no complaints. So why do we want to do this? We've been asked by local residents, why do you want to do this? Because this park is due for spend, it's due for an update, it's due for some money to be spent on it. We want to keep the park, I think you call it current and relevant. So in other words, it's got to be up to date to make sure people are coming to our caravan parks as much as they are other companies' caravan parks. There's obviously a big demand for staycation at the moment. We're told it's what our owners and our holidaymakers want. There is one owner who has objected to this application in the list, but only one. It's what they would like. They ask their complete questionnaires. Once they've finished, they want choice. There is still a nervousness amongst people about going inside and enjoying entertainment, having a drink inside. A lot of people would still prefer to be outside for obvious reasons. Sorry, don't worry. Are you okay? Do you need any clarification?
No.
So there is still a nervousness. The area was used outside last season during COVID and lockdown. I think we all came out of lockdown on the 19th of July. That was Freedom Day, as they called it, I think. So we've used it before. It's proved successful. We've used the bar area. And we're putting a lot of attractions in there. So if I could ask you just to have a look at a plan, which is on page 200 and hole punch my page numbers. That's not very good. It's on page 189 and 190. So 189 is the licensing plan that I'm asking you to, or we're asking you to approve on page 189. And on page 190 is an idea of the other activities that are going on in the area. So there is already a tennis court in the area, there's mini golf, but there's going to be bungee trampolining, a mini aerial adventure, which is, I think it's like high climbing frame, is that right? Sort of high ropes, but it's low ropes because obviously children, don't worry, it's all very safe, councillors. They're not licensable activities under the Licensing Act, but it's all very safe. And also something called a jump tower. And if you just turn to the visuals again of before and after, on pages 213 and 214, you can see the jump tower. So the idea behind the jump tower is you climb onto the jump tower and then you jump off it into a big pillow, a big cushion. and that's where you land. So it's a fun, it's an entertainment area, and the stage is, we would like it to be an integral part of that area. The stage is being positioned on the drawings. On drawing 200, page 200, sorry, 190 and 189, it's positioned so that it is facing towards the complex. So we provided you with a plan, which some of the local residents asked us to do, which is at page 220, which shows in a bit more context. Obviously, the white is the caravan park at page 220 of your agenda, and then you can see the housing and the stage. Have you got black and white plans again, do I assume? So the stage is number 5. I was about to say it's beneath a big green blob of a tree. You won't see it. So if you look towards the bottom left, you can see numbers 1 to 5. And the stage is 5, and the container bar is 2. Would you like a coloured plan? We have a coloured one, but then
I can work it out. Thank you. Unless you always want to see a colour plan.
And just go back to the pictures as to what Caister looks like, because it's going to be based exactly on Caister. That's right, isn't it, Chris? It will look just like that. So that's Caister on pages 208 to 211. There have been references made to light pollution. It has a black screen to the back. It has a screen actually behind, but it has as you can see, a black canopy over the top of it for light pollution to make sure there is no light pollution escape. The stage is approximately 6 meters by 4. And what happens on it? That's what you want to know. This is the entertainment schedule we can't provide on a regular. We'll do it monthly, but during the daytime, earlier, it's very much things like, I'm going to give you some examples now. If you're not familiar with Haven children's characters, there's things like Dino Explorers, which is Dino Explorers. Sorry, Dino Explorers. It's an interactive show all about dinosaurs, and we have Totsie Time, which is family light entertainment, Fairy Tale Engineers interactive storytelling. We do have a puppeteer. We have some bingo. Then you'll move into the afternoon where we may have a movie, showing of a film. And then in the evening, you have visiting acts. So these are tribute acts. So things like, and I've been told Ed Sheeran's one that we get. We have a Katy Perry, a Lady Gaga. So these are people who travel around the Haven estate of parks performing. And the first performance would normally be at 7 o'clock with one of these tribute acts. Maximum 45 minutes, normally a 15-minute, half an hour break, and then another 45 minutes. So it's very close to the 9 o'clock cutoff actually for live recording music, but it might go on beyond that, which is why we've gone for 9:30. Although, of course, legally, we can actually carry on to 11 o'clock, but we will stick with what we're saying we're going to do, councillors. So those acts are there, the tribute acts are there typically during peak, which is July, August, September?
6 weeks, December, July and August.
July and August, so they're typically there during peak, although they may be there on other occasions ad hoc as well during other holidays. But that's typically the day's entertainment on the stage. There may be, we may have a further movie after the last act up until 11 o'clock. So the loudest things would be the, if there was no limiter on it, would be the showing of films. It would also be the live music, the tribute acts. I have just had a note, of course, this is all weather dependent. So whilst we may give local residents a schedule, that could easily change if it's raining, etc. So that's what the scheduled entertainment is. But the critical point is, and I take the point about the noise report from the gentleman. It was sent to your environmental protection team on Monday, the 28th of March. And they have obviously therefore studied it. And as a result of that, those conditions that you've actually got there were sent to me as a composite set of conditions from your environmental protection team. So the experts, if you like, your experts. They wouldn't have done that if we thought Matthew, who sat to the far left, was making the figures up. Would you like me to take you through the noise assessment report? I was going to do it quickly, but it's quite technical. I was going to try and do it myself.
Only if you can do it very briefly, because it's quite a lot, isn't there? It's quite.
Okay, I'll do it as briefly as possible. Obviously, you can read it yourselves. The background is on page 161 of your agenda as to why it was done, about the speakers, the stage. And then on page 162, it explains that baseline measurements were taken. So I've done quite a few of these because we do not just for this client, but dare I say some other caravan park clients, they do have outdoor areas and they will do a noise assessment report. This was done later than we wanted because of the storms down here. It wasn't just the Burnham breeze, it was various named storms, and we wanted to do it at the end of Feb, early March, but it was not possible to do this until the 10th to the 14th of March. So what you can see on page 162, there are 2 noise sensitive locations which are picked, and those locations, councillors, are shown on page 186. Rubbish, not shown on 186 at all. They're shown on a page 177 as NSL1 and NSL2. And NSL1 is to the east, which is towards Bute Crescent, Atlantic Crescent, and NSL2, which is to the north towards Maple Drive. And background readings are taken there. And as a result of those background readings, it then shows this is the level of background noise at those 2 points. And this was done in the second week of March. So this wasn't done at the height of summer when the holiday park and Burnham is at its busiest. And when we would have been criticised that the background noise levels would be higher. It was done in the second 2 weeks of March. I think the park had just started to open, had it, Mike? Would that be right? But obviously very few visitors in the middle of March. So having done those background readings, then on pages, I'm going very quick through this, councillors, on pages 165 and 166, it explains what the background noise levels are at those 2 points. And then on page 167 and 168, it talks about the methodology and the codes of practice you could use to make sure that the level of noise that you can hear inside somebody's house is virtually inaudible. You can never say inaudibility, and this is something that was a legal case actually, Mr. Osborne Minor, because what's inaudible to one person might not be to another. If my daughter can hear things I just cannot hear, so it's very difficult to define that. But we've used here a basis which is set out in the Acoustic Bulletin's Good Practice Guide, and that is what Matthew would use, and it sets out what the levels should be to make sure that inside those houses it's virtually inaudible. And those levels are then set on page 170, we set the levels at 3 meters from the stage, it's 77 dBA. At 10 meters from the proposed stage area, it's 72 dBA. That's got to be set. That when we commission the sound system, it will be set, the limiter will be set, it will be locked away. The only people with keys will be your entertainment manager. It will be set away, it will be locked away. We will ask your environmental protection team to come down and set it with us, and it will be set at that level. Now, my understanding from Matthew, and I'm sure he'll confirm when the questions start coming, is that inaudibility inside somebody's house, we would also expect there to be no music, noise levels above background levels within people's gardens as well, which is what the residents say, quite rightly, they want to enjoy their gardens during the summer. And of course, you're at peak time when we'll be playing the entertainment and the acts, and that's when residents want to be enjoying their gardens in July and August. We quite understand that. The beauty is, if the noise levels are too loud, there is a condition in here that says if it is a substantiated complaint, that noise limiter will be turned down. Okay, so we have to turn the limiter down. If not, we'll be back before you and you'll take all of this permission off us that we can do. And that's a £150,000 stage that won't be used here and will have to be shipped off somewhere else. Unless we're just doing kiddies' characters on it, which doesn't need a license. So that's the noise assessment report. There's then been a bit of work done upon crowd noise, because it might show, we don't need a license or permission to do this. It might show the FA Cup final. It probably won't show the World Cup because that's in Qatar this year in November and December, so it won't be showing that. But it might show a football match because it's live television. You don't need a license to do that. So we've also tried to, because references were made by residents to noise of crowds. We've also there talked about what is the worst case scenario in the event a goal scored, and everybody cheers at once. This area will take no more than 250 people, we'll anticipate, and that's before we start putting benches in there as well. It'll be astroturfed and there'll be benches put in, so we don't anticipate it having any more than 250 people. So to stress, anything then that's going through the amplification system, any amplified noise, music, bingo, anything that's been done on the stage will go through that limiter and will be controlled by the limiter. Just briefly on some of the representations, I will deal with these once obviously we've heard from those objecting. I'll then deal with them in my summing, because obviously I haven't heard what they've got to say. I've nearly finished.
No.
Is that there was a Facebook post, various Facebook posts, a few days after we'd lodged the application. I stress again, this entertainment is not advertised. It's not going to be heard in Burnham Town Centre, a suggestion that young people might flood down to watch an Ed Sheeran tribute band and climb over fences to get in. You won't hear it. They won't know what entertainment's going on because you can only do so if you've got the app, and that is if you book the holiday. It's not a mini Glastonbury. We're not charging people to come in. People won't be parking on streets roundabout to go in because they'll have already parked at their caravans. They won't be walking drunk from Burnham to come to a concert or an event or a gig. We've never had karaoke and we won't, and that's included in the conditions. We did apply for boxing and wrestling because Haven do this strange wrestling event, which is like a pantomime where you've got funny wrestlers, if anybody remembers Giant Haystacks and Big Daddy, and they sort of do a bit of comedy wrestling, but we've withdrawn that, so we won't do that. We don't encourage hen or stag do's, and our terms and conditions reserve the right, if we find out there is one on site, we can kick them out. Got the right to cancel. It won't be floodlit the area. The light pollution will be dealt with by virtue of the black topping. We do have it in other parks. This would be the 4th stage were it to open. We've got them at Caister, Primrose Valley, Golden Sands, and we've just recently obtained approval at All Hallows and also at Thorpe Park. Residents at Caister live approximately 200 metres away to the north, and at Primrose Valley, I think they live even closer than 200 metres to the stage area. Residents have then complained that we'll be keeping people on park and people won't be going into Burnham and spending their money. We feel quite badly about that, don't we, Michael? We have lots of flyers and advertising and receptions to where you can go for your days out. We give 50% off going to Animal Farm and Creeley's theme park, so you can get money off to go in there. We offer discounts in some shops in the town. But we employ 75 people full-time. I'd like to say this because of the accusation that we're just keeping everybody in the park so they won't go elsewhere. We employ 75 people, many of them local, permanently, and at peak we'll employ up to a total of 320 people. So that's what we employ. Music complaints in the past, again, I will get a chance, I'm sure, to address these in my summing up. As I said, I've done this analysis. I suspect, I don't know, that the complaints that have been made in the past may have come from the entertainment in the sales area. If there was noise heard last year, music noise, it will have been as a result of COVID and the ventilation by way of doors and windows being open. But again, I guess I come back to the fact that it's all very good hindsight, and one of the residents said to me, every day's a school day, isn't it? If we had our time again, we would have pre-consulted and had the open days that we held before we lodged the application. I think we'd have still got objections. I think we'd still be here today, councillors, but at least it wouldn't look like we just put this in straight away. But to stress again, There've been no complaints about music noise made to Sedgemoor District Council. As far as I know, the Town Council haven't received anything. We got nothing at head office. We'd held temporary event notices in the past, and I can only find one complaint on record in the last 17 years since the Act kicked in, when we've also had these temporary event notices. Suggestion may be that the complaints have fallen on deaf ears. Well, we've cut the hours back. We've cut the period back. I understand it's 365 days a year, 24 hours a day. Sorry, not 24, 12 hours a day. So we've cut the hours back to address the concerns. We can't really answer these because we don't know about complaints have gone undealt with previously. Michael's email address is now out there, and I know a number of residents have already got it. A letter will be sent, whatever you decide today. The telephone number will go out. We will keep a complaint log. We will have monthly meetings. Michael's already actioned, as I said, before this even started in January 21 and March 22. There were some issues around trees which he dealt with. So that's past music. Future music, as I've said, you've heard my assurances on record. We'll stick to those conditions. We'll stick to the hours. We've made the application properly. And most importantly, the limiter will be fitted. It will be commissioned. We'll invite your environmental protection team down. If it is not right, if the modelling that was done in the report is wrong, well, we will reset it. We'll reset it in conjunction with, and I think it's a requirement of us to reset it with your environmental health officer. But we're not just talking the Licensing Act here, of course. You can review it. You can take it off us. We can be taken to court under the Noise Act. We can have a warning notice slapped on us, and then you can seize the equipment. You can take the whole stage away from us. But also there's, I'm sure you're aware, noise abatement notices can be issued under the Environmental Protection Act. And if you breach one of those, you're facing an unlimited fine. It's an expensive exercise. It's an important exercise for us to keep this park up to date. And thanks for listening, and hopefully I haven't gone on too long. I think I've missed. Thanks, councillors.
Lovely, thank you very much. We continue. Do you want to come for break? No, I'm absolutely fine. Lovely, thank you very much. I just want to clarify one thing quickly, and I know you've said it, but the park is not open to non-residents, correct?
That is correct. Owners and those who booked a holiday.
Super. Okay. Thank you very much.
Well, sorry, the park's open, obviously, to those people. It's the entertainment that isn't open to them. So you can't go and watch the stage and what's going on the stage unless you're resident on the park.
Yeah, that's what I want to know. Thank you very much. Panel members, have you got any questions?
Thank you. Just one item. Obviously, noise is a major factor for people living in the area. Your noise assessment report, you state that the noise survey was undertaken during the season's weekend opening. So what noise would have been there at that particular time?
The report reveals, let me just find it's on page 163. It's the last two paragraphs. So, Councillor Kingham, so the noise survey undertaken during the season weekend opening of the park, including a few days before where the park was closed to the public. Therefore, the represented background and noise levels were lower than you would find when it was at full capacity. As such, the limits assessed are thought to be robust and worst case. So in other words, the background levels were low, which means we've got to keep it lower. Had we done it at high season, it would have been a lot noisier on park. The noise climate at both locations consisted mainly of bird calls, predominantly seagulls and distant traffic noise. Other noise sources contributed to the noise climate with a rustling of nearby foliage. I think that's the trees. There's a lot of trees that are blowing, and nearby holidaymakers. So those were the predominant sounds that you got on the background.
So that is how you've done your assessment?
Yes, so that's the background. So that's how you measure the background noise levels. And then what you do is you then say, well, if that's the background level, we can play the music at this on the stage to make sure that you're not going above that background noise level, because you measure it at the points that are closest to the residential boundaries. Does that make sense, sir?
Thank you. Mr. Weldon, have you got any questions at this stage? And Nigel?
Yeah, just a point of clarification, actually. On the proposed conditions, one of the residents mentioned it's not something I'm particularly familiar with. Where you refer to no karaoke, one of the residents refers to sing-along movies. Would you accept that that is a form of karaoke?
Oh, that's a good question. Is there a definition of karaoke? I always thought karaoke is where you had a karaoke machine with words on the screen and then
My understanding is that what the sing-along movies have, they have the words along the bottom of the screen. So.
Oh, I see. Oh, with words on.
That's why I'm trying to clarify that point.
I think, sorry, karaoke.
Thank you.
Karaoke, I believe that's normally when you actually have a microphone to sing along with. We don't do that. If you've got something on screen, and this is an example because it was mentioned at residents meeting, Frozen on the screen, we're not going to stop children singing along to Let It Go? Let It Go? Oh, we're not going to stop that, councillors. It's a holiday park.
Lovely. So any questions, please, for Jonathan Smith? Can we? No, it's not a registered speaker. Not a registered speaker? No, it's only the yeah. So I'm afraid only the people who are sitting registered speakers can ask questions, but thank you. Anyone? Lovely. Is that Mr. Joyce? Correct. Would you like to go ahead, Mr. Joyce?
Hi. Can I just clarify the number of vans that are on the site? Because the gentleman said that the stage would have no more than 250 people. 800? As far as I'm aware, there are at least 800 vans on the site. Multiplied by 6 people per van, that comes to 4,500 people or 4,800 people.
To answer the question, the maximum capacity on site, I think it's like 2,513, I think I saw somewhere. But safely, that area will not take any more than 250 people. You've got benches as well. It won't be. People will spread out. There's lots of other things to do on the park. So you can go to the live lounge, mash and barrel. I'm just telling you how big the area is and how many people it'll take.
Okay. Lovely. Would you like to pass the microphone down to Gaynor Brown, please? Thank you.
Thank you. I don't do Twitter and Facebook and all this. I've just been handed a review from Caister. It says, don't worry if you can't make it for the evening's entertainment, as you'll be able to hear every word of the screeching karaoke till past 11, even with all windows and doors closed in your caravan. As long as you and your children don't need sleep, you'll be absolutely fine. My caravan was at the furthest corner of the park too. So don't say they haven't stopped. I spoke to the guy who ran the campaign at Caister. They had 22 in lockdown. We had the same problem, right? And they said, if you didn't take any notice of that 22, why should we bother putting in any more?
I don't know if, is there a question?
Is there a question there? Okay, they just wanted questions at the moment. Okay, well that's, okay, that's, okay, no question. Any questions, please? Please go ahead. So it is Louise Peace. Could she have the microphone? Thank you very much. Go ahead, Elizabeth.
I don't know if this constitutes actually a question, but I've heard a lot of what they want me to hear. But if they're reducing the time to just when it's like Easter to October, that's fine. But if there's no issues with noise, there doesn't seem any point in reducing the times they could do the entertainment.
Is that, so would we extend it if there were no issues? Is that the question?
There wasn't meant to be any issues with the noise. There didn't seem any need for you to reduce the times when you could do all the activity. So that's what's concerning me. I don't know which side of that to think.
You're quite right. Under the Live Music Act, we could just do it every day of the year if we wanted to, but we were accused of riding roughshod over local residents. It's now on record that we will do it 3 weeks before Good Friday to the end of October. So it's to give you some assurance that what we say we're going to do, we will do.
Okay. You want to come back?
Question. I don't know if it's pertinent.
Is it a question to?
No.
No. Okay. Well, you've all got your chance in a minute to speak because you're all registered speakers and you're all up next. So if it's not a question to the applicant, then we can wait until you want to speak. Is that okay? Lovely. Have we got any more questions for the applicants at the moment? No? Lovely. Okay. Now we move on to our next part is for the objectors, for you to all have your say. So on my little list here, we're starting with Gaynor Brown. So Gaynor, over to you. Thank you.
Thank you. And thank you for allowing comment. We'll give you 6 legal reasons why you have to refuse this application and put an end to the abuse that Haven have inflicted on us on hundreds of homes for the last 3 years. None of us bought homes next to a fairground, an open-air nightclub, or a cinema. Who would? 12 years ago, the fields behind me were occupied by a lovely community of owner-occupied static vans. They've all been turfed out by Haven, and Michael confirmed that at the first meeting. We've got rid of all them. Right? If you watch their ad, a little boy runs down a deserted beach. Do you then expect to come here and be blasted for over 100 hours of that week's holiday? There are almost 80 identical letters of objection in here. If this is responding to a huge demand like Haven say, where are the letters of support? There's not a single one, not from a customer, an owner, or even a staff member. No one wants this except a greedy American conglomerate who are already making billions out of their 38 sites. So reason 1, under UK law, we have the right to the quiet enjoyment of our homes. Ensuring that right is Sedgemoor's responsibility. We all want that quiet enjoyment back. In May 2021, during lockdown, you granted Haven a license to booze until 2 a.m. with an outside element which had never been permitted before. The restaurant balcony overflows with people drinking, smoking, shouting, swearing to their friends below. So it's so clear we can usually even tell you the names of the participants. And then there's drink up, clear out time, find your way back in the dark, shout goodnight to your mates, and then slam the door of your tin shed. Comes to about 4 o'clock. That's the reality of what you permitted. 2 a.m. would be outrageous in the town, let alone on our doorstep. So reason 2, there was no public knowledge of that application whatsoever. We were in lockdown. No one went out to buy newspapers. Did no panel member or license officer twig that no public response meant no one surrounding knew anything about it? There was no public notification. That makes that license illegal. We did pick up on it this time, although they tried to be quiet with it. But at least we got it in time for some of our neighbours to respond. But when the objections started rolling in, Sedgemoor's response was to bring this panel meeting forward from the 21st of April to today, cutting down the response time by 14 days. That's 2 whole weeks of lost time. This application is a variant on the illegal one. That makes that illegal too. What you fail to understand is it enables a total change in mode of operation. 80 responses was a remarkable response given the shortened time allowed and the record levels of COVID. We're a no call area as well. So no one went door to door to generate these. In addition, almost 300 townsfolk heard about Haven's plans and went out of their way to go into the town's newsagents and ask to sign this petition. The town doesn't want it either. Reason 3, you have to take the weight of objection into account. None of these objectors want Burnham changed into Ibiza or Glastonbury, and Haven's greed should not be allowed to completely change the flavour of our lovely town. They have 38 other sites offering this sort of adult playground already. Go to one of those, or Barrow or Breen instead. Burnham welcomes tourists, but not like this. By the way, we don't do Facebook or Twitter, only one member. Haven called us liars at the meeting and said this was all imagined. Presumably, the hundreds of complaints sent to county, district, town council and police are also imagined. Sleep deprivation apparently gives 80 individual objectors identical nightmares. They claim to have banned hen and stag bookings too, so the all-night parties and the simulated rapes are also imagined. Try booking a lodge that sleeps 8 people. No one asks the age or the sex of the proposed occupants. They don't ask, so they don't know, and that's yet another Haven lie. They lied when they claimed that they didn't need planning permission either because of the Road to Recovery legislation. Why was it down to us to abuse them of that? The covenants on the deed require Haven to maintain their boundaries. The residents of Margaret Crescent get frequent invasions through their shredded fences, and the well-worn paths to the holes are obviously figments of our imagination too. The boxing and the fighting are hardly mentioned in this pack of objections, so removing it makes no material difference to the objections whatsoever. There's no police cover at night, so no one to deal when the problems happen. A 17-year-old in a shed with a torch is not going to do it. We asked the PCC for his comment and said we demanded cover. We've been told there'll be new patrols in Barrow and Bream because that's where they expect the trouble. They're not going to confirm that they'll do it for us. The law doesn't matter to Haven. They've obliterated the wildlife, including 3 protected species, and the TPO protected tree curtain that they promised they would not chop down has been decimated to make room for yet another 59 tin sheds, which would be my new view. Gone is my privacy and security, and the 8 trees I planted aren't OTT anymore, are they? Our lovely green flagged Apex Park will no longer be a beautiful place full of wildlife and tranquility either. Haven's blast zone goes well beyond that. Reason 4, no one bothered to speak to us. So let's make crystal clear what you would have heard. There's no mitigating measures that can make this or the existing abuse of behavior acceptable to us. The entire development is inappropriate in a residential area and it has to be refused outright. After the treatment we've had, there's no compromise either. Limiters only control the noise that goes through them. They don't control the audience or reduce the shouting, the swearing that we hear all day. The Bass Grounds and Oak Tree Arena are miles away from residents, but they were closed down because of noise complaints, and they don't have people's bedrooms mere 200 foot away. So why should it be any different for Haven? It shouldn't. Lord Denny once told me that the planning system always allowed for the concerns of those impacted by development to be heard and listened to. But all those protections are built into the planning application because that's supposed to come first. This license comes later. Sedgemoor have allowed Haven to completely circumvent all those protections. So reason 5, no planning permission. You say it's irrelevant, I say it isn't. And it's not just a festival-sized stage. It's a showground, a bar, a big drop tower, and a huge assisted trampoline. See page 214. These are gigantic bits of fairground equipment and will be a source of constant screaming and shouting. Football till 11 o'clock? Crikey. And lights on huge extended poles. Is there no end to this? There's no mention of any of that in this pack that was sent. Lastly, in 1964, when the council sold 3 plots of land, the farmland went to Holly Marine. Some far-sighted councillor wondered what it could end up with on this site if it was unregulated. So they put a covenant in the deeds. It clearly says, no obnoxious activity will be permitted on this site. Can there be anything more obnoxious than what Haven have planned for us? We think being blasted out for 15 hours a day, 336 days a year, is very obnoxious indeed. Haven and Sedgemoor are bound by that covenant in perpetuity. That means you can't ignore it, change it, or cancel it. It also means that the only thing that can legally be permitted on this site is a residential development. Everything else, the swimming pool, the bars, the one-armed bandits, the boating lake, the supermarket, the restaurants, the takeaway, the late-night football, they're all illegal. And so is any planning permission or license issued by Sedgemoor that have permitted them. If you grant this, our homes lose £20,000 to £40,000 in value overnight. Even triple glazing and air conditioning can't give us back our gardens or make it possible to carry on a conversation with our neighbours in the street. That's the true cost to hundreds of families. It makes our homes unsellable, our bedrooms unsleepable, and us unable to get away from the hell that Haven want to inflict. It's also a huge incentive to take legal action, and we've had so much free help already. Haven have destroyed one community. They sent them all away. You're destroying another, and it's one that support was critical to some of the elderly residents during the pandemic. The 1964 councillors had the balls to say Burnham doesn't want this. Do you have the same?
Thank you, Gaynor. Laura?
Hello, everyone. I'd just like to say that picking up on the very first thing that Gaynor said, we didn't have enough time because I didn't even get my letter of objection in time. And I feel so passionately about this. So I'm actually speaking today on behalf of Mr. and Mrs. Caldwaller, who live in the same road as me, Brew Crescent. They live just 300 metres from the proposed stage area, and all those who will be negatively affected if Haven Holiday Park are granted their licence. They represent the homeowners that surround the holiday park who have the right of enjoyment to their property. Haven's application to hold outside entertainment for 12 hours a day, every day of the week, for 8 months of the year, will not make that possible. Are they supposed to go inside and shut their windows and doors in the hottest time of the year to get away from the noise? And just picking up on one of the things that was said just now by Haven's lawyer, he said we wouldn't hear the noise if we were inside, but we want to enjoy our gardens. Most of us absolutely love our gardens on my street, and we share knowledge of our gardens. We don't want to be inside shut in with triple glazing, which actually has been suggested by Haven online. I have 2 children at home, both of which have sensory processing difficulties and find excessive noise painful. My eldest daughter, Annabelle, is 11 years old, and she has a diagnosis of autism. Noise, particularly unexpected noise, can trigger severe autistic meltdowns that last hours. At the moment, where we're positioned in Brew Crescent, it's so peaceful and quiet, and I can regulate her nervous system and keep her calm. But if there's sudden, unexpected noise, she can't actually understand where the noise is coming from, how long it's going to go on for. So I would be forced to come inside and lock the doors and windows and keep her in when she should be outside having a nice time in the summer holidays. Our home is also meant to be her safe place where she can relax. Her health and our whole family's well-being will be terribly affected if this goes through. She's actually one of 2 autistic children that live in our street, and I know of 1 more on Maple Drive. We have 6 school-aged children living on our street alone. They go to bed at 8 p.m. Haven's plans to hold outside entertainment until 11 p.m. means that they will lose a minimum of 21 hours of sleep per week. It's a child's right to have an education. How will this be possible if they go to school sleep deprived and are too tired to access their learning? Why should their future life chances rest on the expansion of a holiday park that's trying to outgrow its location? As far as the live outside entertainment ceasing at 9:30 p.m. in the evening, followed by the screening of a film, these can be just as noisy, and there's no monitoring of the crowd noise, just like what was mentioned by Nigel Osborne just now about the sing-along. How am I meant to settle my children for school, for education the next day, when there's cheering and singing along for 8 months of the year, every single day until 11 p.m? It's just mind-boggling. With this application, the serving of alcohol outside until 11 p.m. and the opening of a Burger King on site, I believe that this proposal aims to keep guests within the park. And how is that boosting our local economy? My husband goes to bed at 8:30 p.m. because he has to get up at 4 a.m. for a safety critical job running the trains. He has 12-hour shifts of high concentration. He is in charge. The inevitable sleep deprivation that will be caused by this proposal pose a significant risk to others. We also have NHS workers and firefighters on neighbouring streets as well. Frith House, a nursing home off Maple Drive, is 324 metres from the proposed stage. Many of the residents there have dementia. I'd like to know if there's been any consideration for their needs or those of their families. I have been to 2 meetings myself at the park, and the manager has said that they care about their neighbours. I say if they did care about us, they would never ever propose this in the first place. Finally, I'd like to add that following concerns of how this might impact their life, one neighbour on our street has already put their house up for sale on Friday. Thank you for listening. This is what my girls do this morning because they're so concerned about how this is going to impact their life. They're covering their ears and they're in distress because that's the reality of my life and how we live. And we're not the only family with autistic children. Thank you.
Thank you very much. I've got next Mrs. Matthews.
Yes, I'd just like to say my family have lived in our house now for 50 years. We did our research on the holiday park opposite, which was Holly Marine, and moved in because there was no complaints. Bourne Leisure then bought it out in about 1995, which then became Haven Holiday Park, and things changed dramatically. Many planning applications were applied for and passed, and the site was filled with more and more caravans. Then the park became very noisy, and the problem started trying to get the noise levels sorted out, and it wasn't easy. I would also like to state that my house is not opposite a house in Maple Drive. There is a gap with council grass area and the fence to Haven. And people do go over this fence to get into the park. It's happening, youngsters all the time. The fence is now breaking. I've spoken to the manager in Haven and he said he'll have a look at it. I have taken photos and it's now beyond repair. So I don't know what else to do really. And also I'd like to state that we don't just get southeasterly winds. Having lived here for 50 years, I can tell you the wind can change within an hour. So we do get a lot of noise and, you know, how do you go about it? Thank you.
Thank you very much. Mr. Joyce.
Thank you.
Thank you.
At the risk of repeating a number of things that have already been said, I still feel that I have the right to say them.
Of course you do.
Everyone has the right to peace and the enjoyment of their own home without excessive disturbance from others. And this responsibility is placed on your council by government. Please give this full and due consideration, irrespective of the Live Music Act. Noise nuisance disturbance can be detrimental to both physical and mental health. The residents around this site are mostly elderly and retired people. Some already have mental and physical disabilities. In my road alone, there are more than 10 elderly widows living alone and are very vulnerable. I forgot to say that I live in Maple Drive and my garden backs onto the entrance road to the park. A next point I want to make was, what about the caravan occupants themselves? Not all want loud noise, light shows, drunken and antisocial behaviour going on night after night. What about families with young children who need sleep and older visitors who want a quiet seaside holiday? My next point is about noise and light pollution are detrimental to the environment. And whilst the applicant can say it can be controlled, We only live 100 to 200 meters from the noise source. Are you aware how far noise can travel? We have something like Glastonbury as an example, and noise sources from Glastonbury can be heard miles away. Last weekend, we were in our garden and we could clearly hear the bingo caller at the Lighthouse pub, which is over 100 meters from us. And these proposals still give the potential for over 10 hours of noise and light pollution each day. My next point is we already get disturbance from Haven with residents walking and driving to and from the holiday park. There is often swearing, children screaming, dogs barking, and antisocial behaviour. We can also hear activities from the splash pool when the wind is in the right direction. So yes, noise does travel and does travel some considerable distance. My next point is about the site being beside the River Parrett and the River Brew. The River Brew in particular has tidal mudflats that attract wildfowl and waders throughout the year. There are many birds such as redshank, dunlin, shelducks, oystercatchers, many more, and also tidal pools along the bank of the river contain things like little egrets. This whole area has items of ecology and nature that we must preserve. It is therefore essential that the impact of human interference is carefully controlled. My final point is need. Does the site actually need these outdoor facilities? We've heard that Haven say it is progress, but there are lots of buildings within the site already that can accommodate live music, drinking, etc., etc. And why do we need to move these outdoors? I particularly have objection to the fact that these activities, particularly the proposed cinema, would go on till 11 o'clock at night. That seems to me ridiculous. Should the council decide to agree to these applications, I would request that all organised outdoor activity on the site ceases at least 9:30 p.m. That's it, thank you.
Thank you very much. Councillor Keane.
The Haven Holiday Village is just within my electoral ward at the extreme western end. My objection, which was submitted on the 4th of March and is in the agenda pack, was concerned with the noise which is created by outside entertainment. And in spite of numerous concessions offered by the applicant, I wish to maintain my objection as it is written. In addition to this, I wish to ask the panel, if it is within your power to do so, would you make a site visit to see for yourselves the proximity of the dwellings on all sides in relation to the point of the entertainment which is to be reached? There are good maps, accurate maps and charts in the agenda pack, but none of this can give the true nuances of distance and sound and the way sound travels. Also, it is not only the dwellings in the neighbouring streets. I am informed that there are in excess of 800 vans and lodges on the Haven site, of which I am informed over 500 are privately owned. Whilst these homes are an occupation, those users are also our residents, albeit temporary. If you are able to visit the site before you reach a decision, then I believe you would find it visually and interestingly informative. Thank you, Chair.
Thank you, Councillor Keane. Councillor Matthews.
Yeah, thank you, Chair. Yeah, I've somewhat altered what I was going to say because of the late presentation of the noise survey that was done. Well, I think that from a town council point of view and my point of view, we're very concerned about noise. We are not aware that many complaints have been made officially, but I've asked residents about that and they was unaware that they had to make complaints to the town council after they'd made them already to the park. No action was taken by the park. It has caused a major lack of trust between all residents and the caravan park management. This does need addressing, and this licence does not, unfortunately, improve the situation. They're making promises, and they've made promises previously that have not been kept. We want, obviously, all the conditions in the licence to be upheld by our team, our environmental health team, and I'm very, very pleased that at least they've got some form of agreement there. But we are not sure what level that noise is set at. We also, I did make a site visit. I went down on Thursday to one of the meetings with the management. I know the speakers are made so that they do not go out more than 2 meters, etc. But it is site noise that is the concern. I live close to Apex Park, in fact 150 meters. On a Saturday when they are in racing, I know every racer, I know the progress that he's making, I know his position in the race, I know his mother and father, etc. And I'm 150 meters away. And I find that totally objectionable, but I can't blame anybody other than the wind. And that is an unknown problem that these noise surveys do not address. So it is a major problem. I'd just like to say as well that both Councillor Keane and I are on the Friends of Apex Park Committee. No mention, or very little mention, has been mentioned of Apex Park and the nature reserve that is. Noise will be over that and frightening enough very many animals and birds that inhabit there. In fact, I've called them residents because they do take up residence, but they're fleeting at times. But I think that Janet and I do represent them as well. I'm a little bit amused. I know there's been an offer of a monthly meeting with residents that objected. I'm just a little bit amused why Sedgemoor councillors, town councillors, and members of Friends of Apex have been excluded from such meetings, when I think that they have just as much to say about the matters there, and they are direct communicators to Sedgemoor to make sure that the environmental health are aware of any particular problems. If we're excluded, at least environmental health should send a representative, but I'm not sure that is within their remit. We as councillors, certainly town councillors, would like to be involved in that. Could I just say that the BMX noise, when they're actually racing, can be heard at the swimming pool in Burnham. That's 800, 900 yards away. And once again, it's a wind. So when they're saying that they've had this noise survey, it's obviously slanted in favour of the proposal. I would like to say that any licence is granted on a temporary basis until they prove that they can be decent neighbours, which at the moment they can't prove that. I am not saying that this is this current management team. This is a major historical problem going back probably 10 or 15 years. But the current management team have to establish new relationships. I think they've gone a little way forward with the monthly meetings, but I would not like to see them dropped. Obviously, there's no point having them in the winter when they're closed, but I do not want to see a couple of meetings and then Michael decides he's not going to turn up on the third one, and then he sends his junior, and then he sends, which actually defeats the whole objective of having a management meeting with the residents or councillors. Could I also say and stress that, as I said in my letter, I was in the police force when we was I had to head off an invasion of people from the holiday village to the BMX when they was actually having an event that went until midnight. It was quite, could have been quite violent. Luckily it wasn't. But that was because of noise, because their children could not get to sleep. And their children was going to sleep, they wanted to go to bed at 7, 7:30, 8 o'clock, 9 o'clock, not 11 o'clock. These are young kids. You've got 800 caravans on site that will contain a lot of young children, and they should be catered for by the noise stopping earlier, much earlier. So I think that should be taken into account by yourself. Can I also enforce the fact on security? At the moment, I was on the phone to one resident when she was making a complaint when 2 people jumped over the fence near her. Nobody has any idea if there was residents or not. They could go in, as a few years ago, when I was on holiday in Spain, our swimming pool was not very nice. So what we did was walk across the road. I walked across the road and pretended I was a resident of the next hotel, which had a super swimming pool. How do we know that's not happening? Because the security is almost non-existent. The fence being broke down means that anybody can just literally get into that camp without knowledge of any security or management. So therefore, there is a potential, not necessarily it's possible, but it's probable that people could cause trouble in there. And I think that security needs beefing up a little bit. I was quite taken aback last week. I went into Tesco's in Burnham, and the security chap came towards me, and I was frightened to death. He was about 92-year-old with a stoop, and I thought, I am frightened. I'm not going to shoplift because I've seen him. So I think that we need to make sure that the security personnel are of a certain standard. I think that's about it. I might have missed some things out because I've been trying to alter my speech in the advent of the new information that we received. But right, thank you for listening.
Thank you. Thank you, Councillor Matthews. Next we have Elizabeth Wiles.
I'm slightly embarrassed because I am not in any way dropping my objection, but I've tried to formulate responses to what we've learnt today. My original objection is as appendix number 94 and refers to the fact that my personal experience as a resident of Brew Crescent says that I believe that the nuisance caused to neighbours in terms of noise levels from outdoor events would be considerable. It went further than that. The application I submitted was very broad and open, and I think that's led to the massive number of objections that we've seen. So well done everybody for objecting, because there was no way of knowing that this was going on except somebody who is on Facebook, we've had a comment about that earlier, telling me, because I don't do that either. So it did seem a bit, not exactly sneaky, but a bit quiet. It wasn't actually well above the parapet. But that has led to the background things that have gone on before today, the proposed conditions to be applied, and the goodwill, frankly, shown by the applicants in supporting these. despite the licence under the Live Music Act allowing them to do what they want. The written conditions, as they're down here, I find quite reassuring. The monthly meetings and 24/7 contact that's been offered, I appreciate, and knowing in advance what music will be. The reassurances offered by the Haven management to the local site meeting that I attended, emphasised again, as we heard from Mr. Smith, children's entertainment likely, and 3 to 4 days a week probably. But those are not actually written in the conditions. So I'm wondering whether, if you're minded to grant a licence, whether that, could go into that as well. Perhaps even as Mr. Matthews mentioned, a limited term licence. I think I would be concerned, I'm quite reassured to say, but by all the noise limitation and the monitoring that's going on, I think that's good. But I'm concerned that if we just grant the licence on this sort of 365 days, I know they won't be using it for that. I accept that that is an offer that's been made, that it could just creep up to the kind of thing that has left so many residents so upset and concerned and distressed. I don't mean to, decry that at all. It's just that my personal experiences have not been as bad as other people's have. As a majority of the current complaints you're saying, sound complaints have come from the east, is there any possibility for things like the speakers being altered, reorientated, the stage even be reorientated according to weather conditions? That's probably a big ask, but again, that might alleviate some of the issues. But as it stands, the noise thing, I think, is being addressed as well as possible. I do have concerns about, or I did have concerns about it being open to other people. That now has been made quite clear that, nobody will be allowed on. But again, I don't see where the security is to police that. And my other main objection was that any outdoor event is more difficult to police, and the amount of security that they're talking about for the actual event, as opposed to on and off the park, seems to be woefully inadequate. And I think that should be readdressed as well. So while I am reassured by a lot of things, I'm not dropping my objection. So I'm not stepping back from this, but I just wanted to say that I think efforts are being made. And I think if a few more might be made, it might well pass muster for the residents. Thank you.
Thank you. Can I just... Thank you. This lady's perfectly entitled to her opinion, and she is hearing what has been said and how they're changing things. So please don't, absolutely, but don't heckle her for it. She's entitled to her opinion. Can I just point out, I was going to say to you, in option 4 in our agenda here, it says the options that we have as a licensing panel here to grant, yes. And so, of course, this is up for myself and our panel. We sit and think very hard about this when we leave this room, and we can decide what we want to do and how we think it should happen. Okay, so that does happen. Thank you very much. Next, we have Louise Peace. Thank you, Louise. Ooh, sorry. Try the good one.
I've just got a few odd things. I was away for the last 10 days, so I saw, I think, in the pack that there was this letter sent out about an event last May to neighbours. No, that was it. I mean, like I say, I've been out the loop. I have been away, and I was really surprised to see a copy of a letter. I couldn't locate it now, and I was just surprised because I'm not familiar with it. I mean, I spoke to Liz because she's next door, and that's the only person I've seen. So I was inquiring about that. I was also quite put out that I received this letter of a dear valued neighbour. I mentioned at the meetings in the past, some of the owners have been very, very mindful of us as neighbours, and it's been lovely to live on the edge. But I've only ever had this notification since the planning for the licensing's gone in, and it just seems a little bit sour and hollow to call me an important, a valued neighbour. the complaints log, I understand, but I got to say I'm a bit sceptical as to who's going to push to make sure they put it in the log, because if I'm doing my usual, I'm ringing up from my noisy back garden, I don't know that it is actually going to be logged. I've rung up in the past and the answer they've said to me is, we've got a music license, almost, so, you know, don't even bother doing anything about it. So my objection is that they don't manage the issues that they've got. It may be historical, maybe previous managers, etc. But it doesn't fill me with much confidence that, you know, they really are bothered about us as neighbours. That's it.
Thank you very much. And last I have Mr. Collard. Thank you.
I'll save you a lot of time because everything I was going to say has already been said far
Yes, you
better than
have.
what I could say it, right? The only thing I will say is my philosophy is people could do what they're in their own house or their own premises as long as it don't impact on mine. Right? And the other thing is you've been spoken to with a lot more respect from this lot than what I was on the day. Thank you very much.
Thank you. Okay. Has anybody got any questions to the objectors at all? Has anyone want to pull up on anything? Chaps? No? Okay. Legal? Nigel? No? Over to you lot. Have you got some things? Sorry, not you lot. That sounds very rude. Over to the applicants. That was very rude of me. There's just a lot of you. Would you like to answer any of the sort of fears?
So I guess I'm not actually asking questions, but if I can allay some fears and just address some of the points, would that be in order?
Fabulous. Thank you very much.
Okay, thank you. First of all, this is recorded, and there have been 3 comments made which I take exception to. First of all, I think 2 of them were by Gaynor Brown. We did not call Gaynor Brown a liar. We may have disagreed with what she said. Does not mean we call her a liar. I'm not quite sure when she's referring to the hen and stag parties, and I do take exception to the suggestion of a simulated rape. I mean, this is a public meeting, councillors. If there's evidence of that, it should be put to you. And I also take exception to the fact that online, Bourne Leisure or the holding company have suggested that residents should install triple glazing. If that's the case, I'd like to see where that is. So, but just to allay some of the fears, the first Gaynor Brown talked about us chopping trees down to make way for the statics. It's not really relevant for you today, councillors, but just to assure you, we have not chopped any trees down. We're actually going away. I just wonder if Gaynor Brown could let me talk without.
We are here just today to talk about this application and not past things that have happened. And could you let them speak, Gaynor? Thank you. I understand your frustrations.
So in terms of the static, we haven't chopped them down. We're actually going from touring back to static caravans, and we have the appropriate site license for caravans to go on there. Just to allay your concerns and issues around us selling booze to O200 by way of the application which was made last year, we already have a premises license that has been in place since 2005 for a 2 o'clock alcohol sales within the complex. We've always had a 2 o'clock. The application that was made last year was for an 11 o'clock, 11 till 11 for outdoor alcohol sales. We've always had a 2 o'clock licence, councillors. I don't quite know why Gaynor Brown's suggesting that the hearing was brought forward from the 21st of April to today. Whether that's some collusion on our part or yours, I don't know, but you will know you must hold a hearing within 28 days of the end of the consultation period. So you had to hold a hearing, I think, by the 5th of April. So I think you've just about snuck it in time. I don't know what that suggestion is. Gaynor Brown has said you must take weight of the number of objections into consideration. No, you mustn't. You look at evidence, councillors, before you. There's no case law that says the more people who object, you must refuse it. You look at the balance of evidence. the fact that planning permission, I have spoken to our planners, we're getting into planning and I said I wouldn't, but our planners have applied for planning permission. There's been 2 requests for further information from Sedgemoor, and at no point have we said we don't need planning for a stage. In terms of police, no police cover, well, the police would have put a representation in councillors if they were concerned about cover. And the very fact that the MPCC told Gaynor Brown that they expect the trouble in Barrow and Bream, we're obviously not expecting it at Burnham. In terms of what can be heard in the gardens, the actual noise assessment report that was done, it measures the readings actually the other side inside the caravan park, not in the gardens, not inside. It measures the levels that should be played and should be set in terms of the actual noise sensitive locations, which are actually in the caravan park. That's not in the garden. So in terms of your levels within the garden itself, if the levels are not raising the background within the park itself, they should not be raising the levels within people's gardens. And I stress again that we aren't bound by those initial levels. They will be set, and your environmental protection team has said the levels we've suggested in here are reasonable, and that's what we're going to be basing them upon. But if it is that it can be heard in people's gardens, it's a nuisance in their gardens, of course we'll have to turn it down. Otherwise, we'll be brought back for a review by residents or by your environmental protection team, and we'll lose this right. Sing-alongs and crowd noise, I would just ask you to have a look at pages 171 and 172 of the report when you do retire, because we do take the point that you will have people watching the stage. We're not going to, neither could we, because it's not under our control, stop children singing along to a movie. You've heard the rough number of people that could be in that area, and somebody who mentioned a site visit, I think it was Councillor Keane, we'd have absolutely no problem with you coming to visit it. You'll see it's not a Glastonbury style or size stage, nor is it anything like a Glastonbury size area. You can see it for yourselves. But we wouldn't stop children who might want to sing along to a song who are on holiday. But it does stress in the report on pages 171 and 172, and the levels you can see there on page 172 of if a goal was scored, and they've measured this as if it was in a stadium and then reduced it by 3/4, that's the sort of one-off noise you would get from people. To think that, I don't know, 200 children who might be in the area could all, and there'd be a lot less than that because they have the parents with them, would all suddenly sing in concertina to Frozen and would be deafening out local residents. On the balance of probabilities, councillors, just isn't going to happen. In terms of karaoke, quite happy to agree that karaoke is anything whereby you have a microphone and you're singing along as a customer, holidaymaker. We won't do that. The lighthouse, just mentioned, I think there was some bingo coming from the lighthouse. Well, of course, the lighthouse, likewise the BMX track, they won't be going through a limiter. So their tannoy system, I'd be amazed if that's got a limiter fitted. So whilst there's reference made to hearing it, they won't be going through a limiter as we are. The number of owners on site, well, we've got to make sure we don't upset our owners. These are our owners. They pay us pitch fees, site fees, are they called? Yes, and we do have 500 or so. They're all aware of what we're doing because they have our newsletters. So they're fully aware. We did have one objection from one. Councillor Matthews mentioned that we've made promises previously and not kept them. I'm not sure what that relates to. In terms of moving the stage around, which was a suggestion, this is a full-on stage. You wouldn't suddenly be able to one day move it because the wind has changed direction. But the noise readings here do assume when taking the readings for Maple Drive to the north, that you've got a southerly going to the north. That's right, isn't it? Yeah. And for the calculations, and it assumes for those towards Brew Crescent and Atlantic Crescent that you've got a westerly going to the east, and I think that's generally the prevailing Burnham breeze. I think is typically a west to easterly. So those wind directions are already taken into account on there. There was a suggestion that we could look for a trial period. We'll be investing somewhere in the region of £200,000 in this stage, which is an expensive trial period. But we would, of course, we would be bound by what we've said at this meeting and what we're doing. So if we don't live up to it and we lose it after 3 months or so, effectively we've wasted a huge investment on it. And I think finally there has been some suggestion that we should be having more security on site. At peak we can have up to 8 or 9 security on site, and they need beefing up. I think one of the councillors, Councillor Matthews, said, well, again, there's no police rep, and we've had no advice from the police to beef them up, and we wouldn't do so. So that's just addressing some of the points made as opposed to questions, Councillor. Sorry, answering or making a question. Thank you.
I didn't ask Mr. Weldon if you had anything to say to the objectors or anything you wanted to. There was only one thing I was slightly made aware of that you could answer, was that something that Gaynor had said about her point number 2, no public knowledge of the application and the illegal variant. Can you, can you shed any light on the illegal variant? Thank you.
I can, yeah. Last year's application effectively was made in accordance with what the applicants described. It was made on the 19th of May 2021, and that was just to seek the outside retail sale of alcohol outside of the main complex. The main complex has been licensed for some time until 0200, and this was the outside area only that we were looking at last year, sale of alcohol from a bar in an outside area. The emails notifying the regulatory bodies and interested parties were sent out the day after the application was received, which is the first day of the consultation period, as you know. And it was placed in the newspaper on the 27th of May 2021, which I think was a local one to Burnham, and it was on the council website. So in terms of an application, it was properly served and dealt with. I do have a question as well, which one of my questions was going to be to Gaynor, but I think you've clarified that. Could I just ask Mrs. Maynard, I think it is, that you are, you're not an objector, are you? You are representing Mr. and Mrs. Cadwallader, is that correct? Which I think on the application relates to appendices 20 and 21, is that correct? Okay, thank you. I just wanted to clarify that point.
Thank you. Right, I think at this stage we'll do some summing up so that myself and my fellow panel members can leave the room and get on and make some decisions about this application today. So I'll start with you, Mr. Weldon. Would you like to?
I don't think I've got much further to say in that everybody's had their chance to ask questions. I think I've got no further questions to ask. Thank you, Chair.
Okay. And the only thing that worried me slightly is when I think Mr. Matthews said that people have complained mainly to the holiday park, but no one has made complaints to their town council or Sedgemoor District Council because. Pardon? Yes, but yeah, that's fine. But I was quite surprised that people would only think to just go to the holiday park and not think to go to their district councils. I know they have now, but you know that's kind of what your town council and your district council are there for. Okay, well, you know, our environmental teams take things very seriously. So that's, you know, we're kind of, yeah. Yeah, well, yeah. Okay. Okay.
You know, the trouble that we have in our garden, and yet, you know, I never realised that, you know, I could have gone somewhere else.
Okay. Please do.
Listen to yourself. Thank you very much. We're not sitting here and saying you've never complained, and I have to say I think we were surprised, weren't we, Michael, that I'm not sure how far this goes back, but there had been, it seemed, it was made clear by local residents that they had complained to Park, and they'd either just not been listened to, ignored, or couldn't speak to the general manager. And we do take that on board, Councillor Costello, which is why Michael has, as I said earlier, bravely given his email address out to local residents. If Michael were to leave, they will have the email address for the new manager, and there is also a telephone number there for 24-hour security. And then to back that up, because we did actually find, whilst we were shouted at occasionally, and it was very useful to talk to the local residents, that the monthly meetings will reinforce that and try to build these relationships back, because it took us by surprise, as I've said before, when you look at the complaints to the actual authorities, what little complaints there have been, but we weren't, if it was being made, well, it must have been being made, because the residents say the way it wasn't being logged at our end. So we'll keep a log. You've got the email address, you've got the phone number. And actually I hope, and this often happens with these things, that actually it will make to a much more peaceful coexistence between the park and residents.
Another thing I wanted to point out was, obviously small children stay, and it's the sort of place I would never want to take my small kids because of sleep and noise. It would drive me mad myself. But you have families staying, young families staying. Do they, have there ever been complaints to the holiday park from residents about noise?
I'd have to pass over to Michael on that. But what you can do when you book your holiday, it's a bit like I think you do pay extra, is that right? It's a bit like choosing a seat on Ryanair. You are able to choose a caravan if you wanted a more peaceful holiday, because obviously you have the map of the park, and you can choose where you'd like your park. In terms of owners, who are the ones we'd really sort of look at, we've had one representation to this. Michael, have we had any complaints about, well, because we haven't had the stage there, so we haven't actually had the stage for people to complain.
In general, with noise, people are saying other, people kind of climb over the fences and so forth. I mean, do you have complaints from residents on site?
Yeah, I'll pass over to Michael.
Good morning, committee. In answer to that question, yes, we may have had some complaints previously from holidaymakers about the noise, but hence that's the purpose for the presence of our security team. So they will respond to that. All our holidaymakers have the phone number, and they will call where there's a disturbance of noise, and our security team will investigate straight away. And there have been a couple of occasions in the past where we will ask a holidaymaker to leave. That's in our T's and C's. So if they make unruly noise or profanity or unacceptable behaviour, we'll ask them to leave, as we will with our owners. So that's the reason for the security presence there. But that's minimal in terms of number of times.
Okay, thank you. Right, so summing up, anybody else from our objectors, anybody got anything they'd like to say finally before we disappear to make a decision? Yes, please go ahead, Gaynor.
Got no answer from the police because there's no nighttime cover, but we really truly thought that's what was going on, and it was 3 times in 1 month. Okay, I didn't imagine it, and I didn't imagine the other problems either. And I did complain. You mentioned that before, right? What I got on the result of that complaint was a promise that the trees with the squirrel drays in would not be chopped down. The BBC recorded one being chopped down, and it was broadcast out this morning at 8:30. So I didn't imagine that one either.
Thank you. We're coming down the line, folks, if you want to finish off. Go ahead, please, Laura.
I have a recording from something that kicked off last night that was heard from number 1. I didn't personally record it. It was Mr. and Mrs. Stocks that called it, and I'd like to play it, please. Is that okay? Yeah.
Yeah. What is it?
That sounds like a fight.
And that's come from? Main buildings of? Okay, thank you. Okay. Thank you. Anybody else from the registered speakers who've got anything else they'd like to sum up with before we leave to make some sort of decision?
Just a couple of items. First of all, can you clarify, please, is the licence reviewable on an annual basis, similar to an alcohol licence?
Can we do that? Alan?
It's not renewable, no. It's there's an annual fee, and if the annual fee isn't paid, it can be suspended, but there is no renewal procedure.
Right, so once they've got it, they've got it.
Subject to, I know the applicant has mentioned that if there were substantial complaints, a review could be triggered, which does call into question whether or not the licence would continue, but that would need a hearing of the licensing subcommittee again. I think the applicant alluded to that if there were issues that they couldn't control that led to nuisance. Beyond that, there is the variation process, which is why we're here today. But there's no limited period if it's not established in the application that it is for a limited time-related period.
Thank you. Just one other point. I have, as a resident, consulted with the council. I have had meetings with a tree preservation lady on site, with a representative from the caravan park, because trees have been an issue for many residents whose property is bound, we have a joint fence. To be fair, the lady from the council did explain exactly what the tree preservation order was all about, which ones it covered and which ones it doesn't cover.
Mm-hmm.
So, we have had some interaction with the council.
Good. Councillor Keane, summing up?
Thank you. I would just like to repeat that I believe there would be considerable value in a site visit so that you have the very first-hand information before decisions are made. Thank you.
I hear you, and I'll just say that I haven't been for a site visit before because I like to keep an open mind. I've Google Earthed the whole site, but I didn't particularly want to go and go on site and meet management because I didn't want to appear to be biased and looking like I have to come into this with a completely open mind. I've read all the paperwork and I Google Earth the site so I can see, and we've read all the papers. But that is something that we will decide between us if we feel it's needed. Thank you. Thank you.
Hello.
Hello.
Yeah, could you just say that
Don't start singing.
As a district council and obviously the town council, we welcome Avon to have a caravan park for the employment opportunities that they give to, which is sadly needed in our area. So I hope that we can come to some accommodation which appeases the residents, and of course let's Avon stop there on site and employ the people.
Absolutely. Well, this is what we shall go and deliberate between us.
The job of, is it Job or Patience or whatever you've got to do.
Okay.
And I know you can do it, Polly, so don't worry. Thank you.
Anybody else summing up? Lovely. Louise?
Is it? Yeah. Okay. It's just somebody just mentioned that after Haven suggested that the lucky residents of their site can actually pay more to be further away. We can't actually do anything, and I can only say that I have been there and I have gone inside on a hot day and you have shut the doors and the windows, but you sometimes just cannot escape it.
Yeah. Okay. Would you like to sum up?
Just two things that have just been mentioned. I forgot, sorry, I think is it Mrs. Peace, that I didn't say, I think you that we didn't manage issues as well as we could have done, and I think I've acknowledged that, so I should have said that. In terms of what happened last night, yes, Michael Beck did get an email. There were two individuals who had gone into the swimming pool, who were not allowed in the swimming pool because the swimming pool's closed. They were taken out and they have been kicked off park. So their holiday has been terminated. So yes, we did action it, councillors. The yes, your decision. It's an emotive one. This, and then there are a lot of objections to it clearly, and we must learn and make sure we live side by side, as I've said before, with our residents. We have we've learned things from this, undoubtedly. Undoubtedly, we've learned things from this. The decision you have to make, obviously, is based upon the licensing objectives, and all four have been touched upon. But I suggest it's the public nuisance one which will exercise your mind the most. Your own statement of licensing policy, and obviously the national guidance. That's your statutory duty. The application said there are some consequential minor amendments to plans and little tinkerings, and I'm sure Mr. Osborne will advise you on that. I do remind you again that if you're minded to refuse the entertainment in the stage, we'd still ask you to grant the container bar. There's no music coming out of the container bar, so if you are minded not to be with us on the entertainment, that you grant us the container bar permission at least, because it is a structure that's there. What you're not here to do, of course, councillors, and I have mentioned this in passing, is in terms of case law, is you're not here to review the licence we've currently got. So your decision is made solely on the basis of this application, what we're requesting, and what you need to do to promote the licensing objectives, having regard to the terms of this variation and the likely impact on the promotion of the licensing objectives, particularly public nuisance, on the balance of probabilities, what you need to do. I don't know if I have to address planning. I assume I don't, but I would just simply...
No, you don't.
Okay, thank you. Your policy is very clear on licensing reviews at paragraph 3.3. You also, however, in your policy, it's very good, you refer not only to reviews, but the other powers that are open to you as a licensing authority. And your statement of licensing policy at paragraph 2 then talks about the Noise Act 1996 and the Environmental Protection Act 1990. So it's not just licensing enforcement that can be taken. And just to really back up on what Alan Weldon mentioned about, there is no annual renewal of the premises licence, but this licence could be called into review at any time by environmental protection. Certainly, I think a residential review would probably be regarded as repetitious, and there are guidance around that. But so you don't have to wait a year. If an environmental protection team feel that something needs doing, you don't have to wait a year on year. Your policy talks about protecting the amenity of businesses and residents, quite rightly, but then talks about when you're doing that, you're going to consider the steps that the applicant has put forward to prevent music noise, and also to consider the types of entertainment that's been put forward. It is an expensive exercise for us to get wrong, councillors, to effectively sacrifice 150,000, 200,000, have a stage we don't know what to do with. We would have to move it to another park, which would probably already have a stage. So it's something we've got to manage. The national guidance, so I would ask you to, in terms of, you've got the licensing objectives, you've got your own policy, and then the national guidance. And the two key parts I'd ask you to consider, councillors, are paragraph 9.12, and that is the section that advises you that the police are your main source of advice on crime and disorder. And if Avon and Somerset Constabulary had concerns, they would have made representations. But more particularly, paragraph 9.15, that states that you would also expect representations or concerns would be raised about noise nuisance from your environmental health officer. Now, they have made representations. We've had detailed dialogue with them last week to agree those conditions. They've seen the sound assessment report. We will invite them to the commissioning of the system and the setting of the limiter. And if we've got it wrong in any way in that assessment, then they have the right under the licence to ask for it to be reduced. Now, you could say, well, it's a live music act, so you're going to suspend the conditions, then it doesn't bite. it doesn't bite, but you've got it on record from me, I think now 3 times, councillors, that we'll observe those conditions, and if we don't, then we can be taken into review and we can have the permission given by the Live Music Act. It's a benefit taken off it. So, and then finally in the guidance, it talks about an evidence-based decision, and you need to determine what steps to take which are appropriate to promoting the licensing objectives. So what steps is suitable to achieve the promotion of the licensing objectives? And there's a very helpful paragraph in your report right at the end, which asks whether or not, so it's the issue for the panel is whether the application as submitted sufficiently promotes the licensing objectives, and whether the promotion of the objectives requires the application to be granted subject to conditions, or whether it should be rejected because the objectives can't be met by the imposition of conditions. Your lead on noise nuisance environmental health matters is happy that the prevention of public nuisance can be met by the imposition of those conditions. So in deciding what is the appropriate, proportionate, reasonable step to take, is it proportionate, reasonable, appropriate to reject the application out of hand, or on the balance of probabilities, can you promote the licensing objectives by granting the application that's modified and also subject to the conditions? And I would suggest, councillors, that you most definitely can. That we will take this away, we will meet that licensing objectives, we will observe those conditions, and if we don't, councillors, then sadly I will see you back here.
You will indeed.
Thank you very much.
Thank you. Mr. Osborne, is there anything else you'd like to sum up with?
Not so much, just a question. Actually, and that was raised by Councillor Keane, and she talked about whether or not councillors and environmental health would be invited to your monthly meetings and whether you thought that was appropriate.
I do apologise, it was most remiss. Yes, of course, we should have included you on that list of attendees, and of course we will.
Good.
I think I don't know whether environmental protection would want to be there. I'll leave that to your environmental protection team, but we'll certainly invite Councillor Matthews and Councillor Keane if you were minded to grant the application requiring us to do so.
Right, thank you. Well, I think we've reached the point where we, myself and my panel, are going to go out and make our decisions, and we will be back as soon as we possibly can with some form of response to. Thank you very much. The panel have discounted a site visit because we think the issues and the documentation that we've seen are making it unnecessary for us to go to site. Given the amount of evidence submitted by both sides, we feel it prudent to give a decision today. We've got an awful lot to think about and we don't want to rush into this. And so what we've decided to do is give a formal announcement within 5 working days of this meeting. We don't normally do this. Quite often we'll make a decision on the day, but we don't want to rush it because there's an awful lot to think about. So that's what we're going to do. I thank you very much for all attending, and the notice will be out in 5 working days. All right. Thank you very much indeed.